Hey out there, legal warriors. In this video, I'm going to cover a very important topic that I get asked about a lot. And it's funny, I watch a lot of trials, believe it or not, on YouTube and do a lot of analysis. And the question people ask me is, hey, I've got this criminal case. I'm going to go to trial. Should I testify in my own defense or not? That's a complicated question. I'm going to cover both arguments, pro and con. And if you find this area of the law interesting, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, just jumping right into it. What do I mean? Testifying at a trial. Well, in this situation, we're talking about someone's charged with a crime, and their case is actually going typically to a jury trial. Now, do we even have the right to not testify? I mean, can't the prosecutor subpoena us and force us to talk about what happened? And hopefully, many people know this, but not everyone does know, the prosecution cannot force you to testify in your own trial. We cannot be compelled to give evidence against ourselves, at least in a criminal trial. We cannot do that. In civil matters, they can do depositions, they can do all types of stuff, but we're talking about criminal trial. And so what does that really mean, that we can't be compelled to testify, and the evidence of us not testifying can't be used against us in court? Well, that's what the law says, but in reality we have to worry, because while the jury is going to be given an instruction that says you can't use the defendant's silence against them, they don't always follow that instruction. So, a jury, you don't know what's in their head. And whether or not they follow the law, I've been in a jury situation before, and in my opinion, they don't always follow the law. They sort of do what they want. So if we're trying to make an analysis of whether or not someone should testify in their own defense, it really matters what the type of case is. Because here's what the defense bar typically thinks. What the defense bar typically thinks is once the client testifies, now the jury no longer really holds the state to their standard of beyond a reasonable doubt. So in this country, to be found guilty of a criminal matter, the government must prove the case, every element of the crime, against the defendant beyond a reasonable doubt. And now that is defined by case law in different ways in different jurisdictions. But think about that as there has to be a doubt for which a reason can be given. Basically, that's reasonable. There's a lot of different things I could read about what that means, but that's not what this video is about. But so the jury is just 6 or 12 people in most jurisdictions from the public who is evaluating all these witnesses that are saying really bad things about the defendant, right? And the defendant might have some good claims as why it's going to trial, or the defendant might have zero defenses while the case is going to trial because it's a real serious matter. However, this juror, when the defendant doesn't testify, it's easier for the defense to say, the state hasn't proven their case, the evidence isn't enough, and my client is not required to say anything. My client is presumed innocent, and the government needs to prove beyond a reasonable doubt each element for you to find my client guilty. They haven't done that. There's only one verdict you can return. That is a verdict of not guilty. So what happens when you put your client on the stand? Sometimes you have to. Some types of defenses you must put the client on the stand to assert, like self-defense, at least in Washington State. However, when you put that client on the stand, what many defense attorneys think is now the jurors, who have different levels of sophistication, and most of them have zero sophistication when it comes to the law and legal thought, they're more think like, well, do I believe them or not, right? Do I like them or not? And so when you get on the stand to testify in your own defense, originally you are questioned by your defense attorney who's friendly to you, right? And it's going to ask you open-ended questions and things you're expecting. But now the prosecutor gets to cross-examine you and make you look really bad and pick apart everything you say. And even if you're telling the truth, when we're under that type of pressure, we can look like we're not telling the truth. We can have a reaction, something that triggers a feeling in a juror. So many times jurors will get impressions about the testifying witness, not based upon any type of truth or what's going on there. It's based upon who that witness represents to them in their life. Right? They have a bad relationship with their father. The father used to lie a lot. You're a 60-year-old guy testifying. You're being put under pressure. It reminds the juror of their father lying. Now you're a liar. Right? So you have all this exposure when you testify, and it sort of comes down to, does the jury believe the testifying defendant or not? They don't. It's hard for a juror to think of, well, I don't really believe them, but the state hasn't proven their case. So even though I don't believe them, I'm going to say not guilty. So it can be a really difficult, risky thing to put yourself in. So what's the argument for testifying? Well, the only time you can get some defenses out has to come from your mouth. You have a self-defense claim. Well, you have to testify that you were hit or pushed or punched and you had a reasonable fear and that you actually did an act in self-defense. You can't have other people do that for you, at least not in Washington. Additionally, there may be theories of the case that the prosecutor doesn't know about, and the only way you're going to get that theory out is from your own mouth, right? And because there's hearsay rules and all these other things where we can't have, while the government can use what the defendant says out there in public against them, the defendant can't use what they've said to others out in public to help them, because that's self-serving hearsay. So I can't bring someone necessarily to the witness stand to testify of what the defendant said if we're offering to prove it for the truth of the matter asserted, and therefore sometimes that defendant has to testify. Also, if you have no other way to contradict some key facts in the case, sometimes it's worth it for the defendant to get up there and testify to a limited set of facts, because the prosecutor, in theory, can only cross-examine the defendant on what they've testified to. Now, I watch a lot of trials, including some in our own office, but if you ended up testifying in your own case, you want to make sure your defense attorney is hyper-aggressive and trying to interfere and shut down the prosecutor's rhythm and their flow. So many times I see defense attorneys sit on their hands and just let argumentative prosecutors get away with murder. Let them put in little snide comments, and the more argumentative they are with the defendant, the more the jury gets on board. Because remember, the defendant is not sitting in the not guilty chair. The defendant is sitting in the guilty chair. They already think we're guilty, even though we're supposedly presumed innocent. And that's the biggest lie there is in the legal system. Anyone charged with a crime, leave me a comment. Did you feel presumed innocent? You were told you were. For 1 second, did you feel presumed innocent? That's ridiculous. So the arguments, again, for not testifying, you don't open yourself up to cross-examination by the prosecution, and you're more able to get that jury to look at the state's case and not look about whether they like or believe you or not. It takes a masterful defense attorney to be able to put their client on the stand and get them to say what's necessary, hold up to cross-examination, come out with the client being liked. This is going to take a lot of effort, and still get that jury to focus on reasonable doubt, right? Because it's just so hard for them to do, because it's not a rational concept. No one can really define it. And if you get certain types of professions on the jury, they're just never going to understand it, because a lot of people like to split the baby and say close enough. And in criminal defense, the state can't be close enough. They got to get it right. And therefore, we want to hold them to their burden. So should you testify? Usually not. Sometimes you have to, but you need to talk to your local attorney that's handling your case, who knows the local juries and knows what's likely to come into evidence, how the prosecutor's going to present. Are we going to be able to make the prosecutor into the enemy? Are we going to be able to make a bad cop into the enemy? Who are we going to make into the enemy so the client's not? If we have another enemy in the case, that's going to actually lead towards not letting the client testify, because if the client's silent and we've got another enemy, they can imagine how great the client is for all the good things we're saying in opening and stuff like that. So it's not clear, but it's very dangerous if you decide to testify in your own defense. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you've got a criminal matter in Washington State, feel free to reach out to my firm. We've been doing this for more than 25 years. If we get on board, we'll listen to what happened, we'll identify a way forward, and we'll be there for you. Thank you.